You ready? All right, we will call the April 19th Crow Wing County Board of Commissioners special meeting to order. If you'd please join us for the pledge in a moment of silence.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Today's only agenda item is Nelson.
Mr. Chair, I
Roll
need to
call.
roll.
I was just going to say that. Damn.
1 second. This is not going to the right view. There we go. All right, Commissioner Corey,
Here.
Commissioner Brecken.
Here.
Commissioner Barros.
Here.
Commissioner Franzine. Here. Commissioner Hoag.
Here.
All members are present.
All right, thank you. All right, the agenda item today, Nelson Preserve Cartway. Who is going to, Don, are you,
I'd be happy to
or
start
is it
off.
Ryan, or?
No, I told Ryan that I would
Okay.
take the lead today, and I was expecting to see at least one more attorney on the screen. Is there anyone else there yet, Therese?
No, sir.
Well, and since I see Mr. Kruger's here, he got the same link I sent to everybody else. If it worked for him, it should have worked for everybody. Mr. Chairman, members of the board, we're here today as a special setting for the Cartway petition by the Nelson Preserve Cartway petition, which was filed with the county back in 2019, early 2020. Then through a series of different situations, COVID among other things kept getting continued till we get to where we are here today. I know I spent quite a bit of time yesterday trying to re-review the file and bring my simple country lawyer brain back up to speed with where we're at on this. So the petition was filed, and this predates Mr. Kruger's participation. Initially, the petitioners, or the Middletons, were represented by Mr. Barnum, who unfortunately was unable to continue through. Mr. Kruger took over. But we received a petition for a cartway. There were some questions about appropriate service, so that never came before the county board. That petition process was started over by Mr. Barnum on behalf of the Middletons, which then resulted in a proceeding before the county board, I believe back on October 13th, 2020, which was the proceeding in front of the board. But on September 28th, 2020, I believe was the on-site date where you all went to the property. And I think everyone made it, at least those that were going to, viewed the proposed routes and the involved land. A question arose late last week in regards to whether an appropriate order and notice of hearing was ever issued by the board. And I've been working on that, and I now have copies of the August 13th, 2020 letter or orders and notice of hearings, which were signed and I believe provided to petitioner's attorney to serve on all the parties, which set the September and October on-site in September, the hearing for October, which then ultimately we had. So I believe that the initial, up to now, I didn't know if the initial statutory obligations had been met. I can't tell you about the service because the petitioner's attorney would have done that initial service. And I don't know that any verification was filed with the county, at least I can't find it. Then through, again, a series of things, we continued to where we were going to be meeting again in May, which was then expedited to today. Last week, I spoke with some of the one of the landowners, and I spoke with the attorneys for both Mr. Unger and for the Middletons. Mr. Unger being the landowner, the Middletons being the petitioner. Those would be kind of synonymous because I slip in and out of those two things. Whether actual notice has been given to all the affected landowners. And as far as today's proceeding, actual notice was not provided to all the landowners, only to the two attorneys. I take full responsibility for that. I had offered to shepherd this process through for you, and I just, once we put it back on the agenda, since I don't normally send out the notices, again, my simple country brain didn't function past that point in time. And so, other than the two attorneys and the Middletons and the Ungers, actual notice was not given to anybody else. So, we are unable to proceed forward here today with setting a route because of that. But even if that actual notice had gone out, you would, in my legal opinion, be unable to proceed today. If you recall back on October 13th, 2020, when I made the recommendation to you that this was an appropriate petition, it was a qualifying petition, I made some estimates of potential expenses and damages for you, the county board, to consider. My estimate was $70,000. I believe Mr. Unger's attorney, Attorney Myers, was requesting a $250,000 deposit. And I don't know that the Middletons or Mr. Kruger at the time or Mr. Kruger's associate made any requests, but at least on July 14, 2021, there was a request via email or letter requesting consideration to reduce the $70,000 to a $15,000 damage deposit, which no action was ever taken on. So in any event, in October of 2020, you established a $70,000. In my opinion, before you can do anything else, that has to be deposited with the county. It has not been. As of late yesterday afternoon, and I'm pretty sure Central Administration would have told me if they received it today, so as of today, that money's not been deposited, so the county cannot proceed forward, in my opinion, until that deposit is made. Now, I know Mr. Kruger wants to request at some point today that you consider reducing that. I'm sure, I don't know what position Mr. Meyer would take on behalf of Mr. Unger or any of the other landowners who are not represented by council. I can just tell you that I spoke with both lawyers yesterday. I know Mr. Kruger ultimately is going to want to make that pitch to you today. That's your discretion to whether you want to allow them and what you want to do. I do not believe personally that you should reduce it, but it is not my call. I'm just trying to give you a staff type recommendation. So that's where we sit today. I think we can establish another date today. Whatever that date would be, May 10th was when this was originally set. We just need to be able to give 10 days notice, and we need to have 10 days posted notice on wherever we post things these days. On whatever bulletin board we consider the auditor's posting board, we can put it on our website, and there's discretion, there's dispute amongst lawyers whether that's adequate posting or not. So we will do both, I'm assuming. And we will send actual notice to the affected landowners. And again, that's not Teresa's fault. I'm owning that, so nobody should get in trouble but me for that. And then I did provide you some information from Mr. Meyer. I did not put that in the packet for today's hearing because this is like a pseudo-judicial type proceeding, and so I did not believe it should go into the public record. I still do not think it should go into the public record until such time as we actually have the hearing, so please keep that information confidential. I apologize to the media and the others that might want to see it, but it's no different than any other active judicial type or pseudo-judicial type of information. Ultimately, it would all come out. And if you did review those various appraisers from the landowner, Mr. Unger's perspective, you could, I think, take that into consideration whether you wish to reduce the $70,000 required bond or not. I did also yesterday re-review much case law in regards to that, and again, attorneys are going to have differences of opinions of that. It is discretionary whether you require the bond, but if you don't require the bond and a cartway will be granted, it's not optional. You're going to have to grant a cartway someplace since it qualifies, in my opinion again. Then there will be damages. If the petitioner generically speaking, now chooses not to pay those damages, then the cartway cannot be created and we can't give permission to go forward. But you still have a granted cartway petition on the books. Some case law would suggest then we would have obligations, once that's established, to assist them in collecting damages or vacate the cartway. Hence, you put the damages up front or have some kind of a deposit up front so that if and when the cartway is granted, you have the money to distribute for county expenses and distribute for the property owners that are affected. Hopefully, we've collected enough. If not, they would still have to pay the difference, the petitioners would, prior to being given permission to get to the cartway. So at this point in time, though we can set another tentative date, I don't believe we can actually hold the hearing unless the money is deposited, whatever that amount of money would be, which is currently $70,000, and that's pursuant to Minnesota law when I say that. With that, I can stop. I can see if you have any questions, and Mr. Chair, however you would wish to proceed today, then I guess I would defer to you.
Are there any questions for Don, or? Mr. Kruger, would you have any comments?
Oh, I think he's muted.
Oh,
Can you go and mute yourself?
Now can you hear me? I'm sorry.
Yep.
Good morning, members of the board. Good morning, Don. I just want to speak to this bond for costs. The statute says that the amount of damages shall be paid by the petitioner to the town board before the cartway is open. I think the relevant portion that you want to do to protect yourself is have damages deposited in a sufficient sum to pay the costs that the county is incurring in conducting these proceedings. You have the hook on the petitioner. You won't open the cartway if he doesn't pay the damages. But that doesn't do anything to satisfy the damages that you incur in these proceedings. You have there, once the cartway route is selected and the damages awarded, there are 6 years from that date within which to collect the damages. The people entitled to the damages have a right to do so. I don't believe any case law is clear that the county or the township would have any responsibility to collect those damages. The big thing I see in this case is I've been practicing law here for 42 years, and I've done a lot of these cartways. I have never, ever seen $70,000 deposited as damages in a case like this. $15,000 to $20,000 is the norm, and that's why I requested $15,000. When you put a $70,000 figure on this, now you're basically deterring the right of the petitioner, who has $70,000 to submit in order to have a cartway determined. How do you determine rationally what an estimate of damages would be without establishing where the cartway is going to be granted? You can't. I think that the prudent thing to do is for the county to protect themselves and require a $15,000 to $20,000 bond. The landowners are protected by statute. They have 6 years. The damages will be determined by the board at the time that the cartway is determined. Otherwise, it's such a chilling effect. You're basically taking away the citizen's right to petition for a cartway. Thank you.
Mr. Chair.
Yeah, go ahead, Commissioner.
I guess, could somebody give me a definition of damages? What are when you say damages, is that damages to the, I kind of interpret that as the damage to the trees or whatever it is going down the cartway, or are you talking about the expenses that the county's incurring? What are you talking about damages?
If I may, Don, you're talking two different things. You have the form of damages incurred by the county in just conducting the proceedings, your costs of your meetings, your costs for postings, your costs for service. Those types of things are the county's damages. Then you have the damages that are awarded to the landowner, and basically that's the diminution or decrease in the value of the land by reason of the cartway going through it. The landowner doesn't lose the use of the land. but now it's subject to the use of the people who have the cartway. And a cartway can be private or it can be public. And that goes into effect in determining what the damages are also. You're looking at basically a diminished in value. What is stumpage value? Usually you're looking at appraised value of property, all right? And what's the difference in value of that appraisal with versus without the cartway? That's the landowner's damages. But again, the county has the out-of-pocket damages, which you have no way really to recover after the cartway is granted, where the cartway can't be opened until the landowners are paid their damages, so they have a hook. So my recommendation, and the way basically I've done it over all these years with other townships, is the township is protected by this bond or by this deposit, so that they're ensured that this proceeding isn't costing them and the taxpayers of the county any money to do this. The landowner is protected in that the cartway isn't opened until they are paid.
Mr. Chair, Commissioner Coring, I think the answer to your question would depend on which attorney you're asking.
Yes, I think you're right, Mr. Administrator. I guess, as far as the county board is concerned, we get the same salary, so it isn't costing us anymore. This is what our job is, to do this kind of stuff. So I don't think we're incurring any extra cost.
If I may, Commissioner Coring. So Mr. Kruger speaks in terms of damages. You've heard me say costs are out-of-pocket expenses that the county incurs through the proceeding. It's the same thing, and we are entitled to reimbursement for staff time and actual out-of-pocket expenses like postage and things like that. In determining the costs associated with the estimates that I made in this particular situation, I also took into consideration the cost to create the road and maintain the road as it exists at this point in time. Since you have a road going through, that was how I came up with part of my initial estimate based on the original information we received. I believe you all received it on the on-site verbally from the developer. At least that's my understanding. Other than that, I agree with what Mr. Kruger said. Obviously, I think if Mr. Meyer, just trying to be fair to all in case he's having trouble connecting here today, obviously has a different opinion than Mr. Kruger's based upon his significantly larger number he was asking for back in October of 2020. So I just wanted to supplement the answer because you got two lawyers, you got to get two answers. Okay?
That's fine with me. You go right ahead and do your lawyerly stuff, and I'll do my.
Here he is right now, Your Honor.
Sure.
Your Honor. So
Yeah.
there you go.
Well, so a question. So this is a question to Don, Ryan. So when that $70,000 number, is that the number that's the cost of postage and staff time for the county, and then you're estimating the cost of the damages for trees and whatnot to put the cartway in? Is that the number you're coming up with there?
So what I used in my recommendations back in October of 2020, the cost to put the road in and maintain it up to that point in time, out-of-pocket expenses for the staff, loss of square footage on the parcels that it's going across, primarily Mr. Unger's in this case, and stumpage. And I got my dollars from estimates of the day from Land Services Department. And so I added all that together into my proposed number, Commissioner Coring.
So then another question then is, so if we're collecting that money, then the county is hiring a contractor to put in the cartway and the road itself, and then we're reimbursing them?
No, the statute says that when a cartway is established, it's the county's obligation, the developer gives the money to the county. So the developer in this case is going to have to foot the bill to create the road to the extent it doesn't exist, or reimburse for the road where it was, because we've already made the determination that there is no public necessity or need for this particular road. And so we're not going to spend any county dollars. When a cartway is granted, there will be damages, and so then the petitioner, and I'm just speaking generically, needs to pay to the county the amount of damages determined by the county board, And if it's appealed to district court from county board, and the district court increases or decreases the damages, again, it's the county's job to collect it, and the county's award to forward it on to the affected landowners. That's all by statute. I don't think there's any argument between the three attorneys on that particular portion of it. But no, we will not, in my opinion, be creating this road. That will be the Middletons who would be creating that. But part of what they're asking is to go over a road that already has been created by the landowners in the area.
Okay,
And
I
Mr.
guess
Chairman, I don't know if you want me to, go ahead, Paul. I'm sorry.
I'm not quite following, you know, I guess I don't know how we came up with that number. And what I have concerns about, Don, is, you know, the way the county has evolved, the most important thing we have is to serve our constituents and to serve our customers. And here we have a constituent who's paying property taxes or paying taxes in Crow Wing County. And this has been dragging on for 2 years because some lawyer says, oh, I can't show up. That isn't the way we operate the county board. We set the county board meeting and we have a meeting. And if you can't show up, that's your problem. I don't understand why we're treating this person that has petitioned us this way. And I'm going to be home tomorrow, and I'll tell you what, I'm going to be pretty damn fiery if we don't get this taken care of pretty soon. This lawyerly stuff of dragging things on, it's just, I almost feel like it's just the meter's running, and it's just not right in my mind.
May I address the board?
Sure.
Thank you. First, I think it's COVID that slowed it down. Second, I want to be clear. Access has been offered, but they won't take it. So it's not as if this is landlocked through any activity. It's not the access they want, but their access, a good access, has been offered. So why are we sitting at $70,000? Here's what happens, and this is what the Court of Appeals said, that local governments, county board in this case, are obligated to get money up front to pay the damages for the cartway. The damages are you're taking land from one private owner and giving it to another private owner. And the statute says you can do that, but you gotta pay the private owner from whose land you're taking. So we went out and got appraisals by a very conservative appraisal company who only does appraisals in the northern country and in farmland. And they're showing us that at a minimum, the damages for taking the land from just one party is over $60,000. And then it goes up from there because you're substantially taking a big chunk of property away. Now, as Mr. Kruger says, well, $15,000, and if the petitioner doesn't want to pay it, fine. Well, here's what happens. When you're done, you're going to put in the title records an order for a cartway. And so anybody examining title in the future is going to say, what's this all about? You burdened my property, and the property owner is going to have to say, well, they didn't pay the damages. It's there. I don't know what it means, but they never paid the money, so it never opened up. And the Court of Appeals, in the last decision I know of on this, said local government's got to stop doing that. They got to get enough money up front to make sure that when they take property from one owner and give it to another owner, that there's enough money to pay the damages. So we're not playing the game of, well, it'll be open someday when I feel like paying the money. Can't do that anymore, according to the Court of Appeals. So there are, I believe, 11 property owners you're crossing. So you're taking rights from 11 people, property rights, some more than others, and you're going to take those rights away and give them to this guy so he gets access to his property, and you're entitled to do that. But he's got to pay for it. It's just not going to be $15,000. I mean, you're talking a lot of money. One landowner alone is going to cost over $60,000 for a route, and it's not even the one he wants. The one he wants is like $130,000 in damages. So I'm asking at a minimum to protect the other constituents who you're taking land away from, that you get the $70,000 up front to say, this is serious. This guy's got the money to pay a cartway and open it up if the county board awards it. So there's constituents on both sides here. And again, I'll say, we've offered access. You don't have to do this, but the property owner doesn't want the access we've offered them. It's a good access.
Mr. Chair,
Commissioner,
so just to try to educate myself a little bit more on that question. So 11 property owners are affected by the route, I'm guessing you have a route in your mind. And so those property owners are affected. So then who will determine, well, let's say I'm one of those property owners. Who will determine how much damages I get? And then let's say they go through 100 feet of my property. Then who will determine that? And then where will I get my reimbursement for the damage?
Should I answer that?
70,000.
Oh, okay. That's what we're talking about here. You, the county board, make the decision on damages. We present evidence to you. Mr. Kruger presents evidence to you. You make the decision to say, okay, $10,000 per whatever it is. And
Okay.
then this is what we're talking about. We want money in advance, so when you make your decision to say this is how much money it's going to cost, that the money is in Crow Wing County's bank account to pay us for what you're saying we're entitled to be paid for the taking. That's what the damage deposit is all about. Taking land from somebody, but making sure that if you do that as a county board, the money is there to pay for the land you're taking away. That's the issue.
Then when are those, Mr. Chair, then when are those property owners paid that damage money? When are they paid that?
Before the cartway is open. So the procedure is, let's say you say, yes, but here's the cartway and here's the pathway it's going to go. And these are the property owners, and here's the amount of money we're going to assess for each property owner. Then the petitioner has to pay it if they want the cartway open. But that's the trigger the Court of Appeals says is going wrong here, because petitioners walk away. They say, well, that's too much money. I'm not going to pay $100,000. I don't want to do that. And then the poor property owners stuck with this order in their title records saying there's a cartway here, but it never got opened up, it never got paid. And so you cloud their title without having enough money up front to pay the damages. But that's what I'm asking you to do. I don't think 70 is going to come near to cover it, but that's your decision. But I want money in advance to pay people for what you're taking away from them, so that they're not sitting with this big cloud on their title for the rest of the time.
Mr. Chair.
May I interject something here?
sure.
Look,
What we're talking about, this order for cartway, what the other townships didn't do was hold that order until payment was made. The county nor the township has to file that order for record on anybody's title until the damages for the cartway is paid. And that is the solution to this. The solution is not to come up with some huge sum of money based upon pie in the sky. And yes, there was an offer made, but of course the offer of access was not acceptable, and they knew that when they made the offer. You're talking about trying to set damages when you don't even have the cartway route set yet. The landowner is protected. If there's a cartway granted, there is no order filed of record until such time as the damages has been paid. You avoid the whole problem that the appellate court was talking about. That's a mistake at the township level.
Could I respond to that? First of all, the statute requires that the order be recorded. Second of all, if you're selling property and if there's an unrecorded cartway order out there, you got to disclose it. You just don't rely on the title records. This is a fact. And it'd be fraud if I was to sell my property knowing there's an unrecorded cartway order out there that somebody could come in and pay sometime. So I'm asking you for the minimum amount of damages. I've got an appraisal already given to you by a very conservative company for one party, $70,000 for one party. And if you guys all collectively decide, you know what, damages are way too high, it's only $15,000, he gets the money back. Whatever you don't award goes back. This is a deposit. Or if it's not enough, they have to pay more in. But you can't ignore the order. If you issue that order, it's a cloud on title, whether it's recorded or not. A property owner has to disclose it to a subsequent buyer.
You don't have to, if you don't have to.
Mr. Chair, point of order. Mr. Chair, point of order. Mr. Chair, point of order. These two gentlemen will debate this for as long as you wish. I would suggest that someone needs to be called on by the chair before they speak.
Okay. Well, now that we're quiet, I just wanted to make a quick comment too, is I don't understand how we can set damages when we don't even select a route yet. I just don't get that. And if I'm hearing correctly, there is an opportunity before this cartway is officially passed, if you will, that money is set based on the route we select. In this case, we've got, I don't know how many, half a dozen different routes, but by Mr. Unger as well. We've got 3 from our staff. And why we select $70,000 based on not knowing what impact the route we select will have just seems foolish to me. And I guess I'm looking for maybe some answers on that. I have the feeling there's an opportunity to pay those damages once we do select the route, but to set a number that high just doesn't make sense to me. So I guess if there's 2 things we can accomplish today would to be take a look at the damages and determine if that number should be revised, and 2 is set a damn date that this thing can get done. I just, to Paul's reference, this thing has been over 2 years. For God's sakes, we can trial a murder case quicker than this. And I cannot continue to watch this thing get kicked down the road. So I'm hoping we can at least accomplish that today so people know where this thing stands. And if the lawyers can't be here, so be it. We're going to act and get this thing done. So Mr. Middleton would like to say, can you come to the mic?
Thank you for this opportunity, but I want to make something clear here is, number one, when we bought the property, our papers that we had a prescriptive easement. It said right on the paper, on the documents. What we did is we tried, in fact, the land services team also tried to see if they could get their hands on that document, and were informed that the town hall or something burned down and their records were lost. So we all along thought we had some kind of easement, but obviously we're not attorneys. We bought it just assuming that was the case because we've never had trouble with access with that property. Number 2 is that property, that township road is about 75% of that road was there. I've been hunting that property since I was in high school. And the road, they widened it and made it much nicer, no question, and they put a different entry to it next to Harrison's property. We used to come in that way. The property itself, when it once across that pond, went straight, and they made a little curve towards Unger's property currently now. He offered us access only if we would give him part of our property. It was not money at all. And his issue is, I think we've got an issue with his property partly built on ours. I mean, we looked at it and we're getting a surveyor to survey that, and we're not sure, but it appears as though that happened, and that property, our property, he's been using, and I would like to get out there and take pictures for this group to see what happened to our property. It looks like a dump. He's dumped stuff on that property, he's got other things on our property, and we have not been able to access the property other than he offered for this hunting for us. He's had another guy that was hunting it, a friend of my brother's that he allowed in there to hunt on our property. But I'm sure it was because they're crossing our property to get on the state land. So I want to make sure that we understand that the offer we had for access was not a dollar offer. And the site number 1 that was selected by the land services team was the site that we walked with Unger. At the time, he proposed that we give him, it was 10% of our land, and then it was up 15 if we didn't make a decision by a certain date. That was his offer to us. I think I'd like to make it clear that that property, I think somebody had mentioned along the way that they put $250,000 into that road. I would love to see the receipts on that road. And I don't know where they get 11 people. That there, I think we cross about 7 properties, and it does run around the lake, but we don't go that way. We go strictly to our property. The documents that were handed to Mr. Ryan that showed 3 routes, the one with the route that goes right around his property to the front is actually the old road that went all the way, goes now where the spiles of the property actually on the whole other side of that piece of property. And so most of that's all state land next to it. But at any rate, I think there's some things that have not made clear here. We wanted to reach agreement with them, but it was totally unreasonable. And I think when you see the mediation, if you've got any notes from that, you'll see why.
We're not entitled to any of that, Mr. Milton.
Pardon?
We don't have any information in the mediation, just so you know.
Oh, okay. Well, I'm sorry, but I'm getting to a point where my blood pressure gets out of control just dealing with this whole thing. So, but I think a few things need to be clarified because we were not offered access unless we gave him part of our property. And we weren't willing to do that. So, thank you for that.
Thank you.
Thank you.
If I may, Mr. Chair. It is obviously apparent we're not going to resolve this issue today. I have the whole day scheduled. We can stay here as long as you all want to. My suggestion would be you have a request to consider a reduction of the damage deposit that you previously determined. I'm happy to re-review what my recommendation was based on. I gave you a short scenario already today. So that's one thing I think you can make a determination on. And then I think we need to set another date. For the benefit of Mr. Myers, or Attorney Myers, I actually have copies of the orders that you were asking about and the notice of hearings that previously you maybe didn't get a copy of that set the September and October 2020 dates. I think we have fulfilled those statutory requirements. I owned that we didn't give actual notice to those that were served with those before, so that'll be fixed. And so what I think we need to do today is set another date to come in. Now remember, you're not doing this as the county board. You're doing this as the town board for unorganized territory, and it has to succinctly be remembered that because that's the authority you're functioning on. If this was an organized township, you wouldn't be involved at all. It would be at the town board. So we can set the next date, and you can consider or not reconsider that damage deposit you've required, understanding that if there is a damage deposit, that has to be filed before the next date, or you're not going to be able to do anything then either, in my legal opinion.
What are the wishes of the board? I agree with those 2 items. At least those are 2 we can accomplish today. But let's make sure we've got the notices sent out that whatever date we select, we can determine the route so this thing can get resolved.
Legally, you can determine the route and damages on the same day, but that's awful tough to do, particularly if you select, there's 3 routes proposed right now. If you select one of those, one side is giving you some information, the other side can consider that, but you might have a 4th route. So then I don't know that you want to do it all in one day, but we could do it date A, set your route, date B, with enough time to give notice to everybody, do the damages.
But if we select the route, a lot of that work can be done outside of a boardroom.
Mm-hmm.
So, again, I think if we set the date with the intent of selecting a route, and at that point, then they can go out and get, I guess, accurate damages based on that route.
So one date you could consider, looking into May, would be May 10th, and then whatever 2 weeks later from May 10th is what?
24th.
Those are the regular county board dates. Both of those are more than 10 days away, I believe, so we could get the 10-day notices out. So those, again, I'm just offering you suggestions or things you could consider. You could look further out into the future if you want more work done than that too. You're not tied to those 2 dates.
Well, I don't think it's our intent to push this out any further than need be, so, but I would bring it back to the board to see what the wishes.
Mr.
Would
Chair, if I might ask, I'm still confused on the damages. You know, and I know we set that $70,000 amount at one point, and is there some question whether that is currently not appropriate?
So when I appeared before you in October of 2020, it was my understanding that there was approximately $250,000 invested into the creation, improvement, and maintenance of the road, so I used that number.
So we're talking at this point, just for clarification, the road coming off from the township road.
The road that is in existence today, correct.
Okay.
I forget what it's called. It's called the, Ryan, what's it called again? Marsh Point Road.
Okay, and that comes down to Mr. Unger's driveway.
Yes.
Okay.
And it was my understanding that the cost of that was divided by 12 different people. Again, this is based on the information I had at the time. Adding in the Middleton petition would make it 13. I did simple lawyer math of 250,000 divided by 13 and came up with 19,000 and change. I added that into the square acreage estimates in regards to Mr. Unger's property and stumpage, and had an estimate of approximately $5,000 in county out-of-pocket expenses. And when I added those all up, I added in a little bit of a cushion and came up to a $50,000 to $70,000 range where I anticipated the damages would be because I'm not a land appraiser, and suggested you'd err on the side of the 70, which is what you adopted.
Okay, and that was without a particular route chosen, is that
That was
correct?
just generically speaking, in regards to what I anticipated damages would be. And of course, we have much more information now, but that's what we disclosed and discussed back on the day.
Mr. Chair, I do have a question. You know, with the values of real estate going up like they are those estimates still relevant?
That's a good question. Obviously, there are better people than me to answer that question in the Land Services Department. In anticipation of that question, however, I did do some preliminary checking to see if we saw a significant increase in the per square acre value in that area, and I believe the Land Services is still using the same number as it was before this recent blip for raw land.
Okay.
And again, I can only share with you the information that was shared with me.
So when you use 250,000 for the road, that's the entire road, correct? So given this is only using a portion of that, have you calculated that into it? Or have you just assumed, because this doesn't go anywhere near the end of that road?
So I actually did sit down and say, okay, how far does it go down there? Because back in the day, we anticipated this was the whole road and we're all the property owners, correct? If you take Mr. Meyer's perspective, and I don't mean to pick on Mr. Meyer's or Mr. Kruger's, but if you take one legal perspective, it would be that everyone who has an access or has an easement right to Marsh Point Road is damaged by having a portion of that road turned into a public way or be subject to a cartway, even if it's determined to be private. Another legal perspective would be it's only those people who it's going in front of or crossing their land, and realistically, the only land it's crossing is Mr. Unger's in regards to creation of new road. So there's no question Mr. Unger's going to is going to incur the most amount of damage to his property and his ownership. So if you take that 250 and you divide it in half, because he goes approximately halfway down before you get there, and again, that's just looking at an aerial photo. I don't have surveys or any of that types of stuff. And then if you only take the 9 people that are involved in that particular area, and it might be less than 9 people, but there are 9 parcels. So in development, I have to defer to Mr. Breck, and it's more his expertise. If a developer builds a 9-lot or 9-unit development, the cost of that development is divided by all 9 units, right? And so if I buy 3 of them, I'm paying basically a third of the cost of that development. even though there's going to be more people, I bought 3 lots, because it's not divided per buyer, it's divided per lot when you create or plat something. I'm assuming that's correct, so. So if I take 1/2 of 250 is 125, divided by 9 is 13,888. So instead of me trying to get super creative with attorney math and trying to explain how an attorney's brain works when it comes to numbers, because in the past, you know, that's been pretty confusing to y'all, I kind of stopped right there.
Mr. Chair, if I might ask a question here. If I remember from our site visit out there, the gentleman who, I don't know if he owned the property at the time, but who did the improvement of that roadway has no record of what the actual cost was either. He could not produce any record of what that number was. So when we say 250,000, we don't know that that's, I mean, I could pull a number out of the air myself and decide what it is.
The only information I have is verbal. I don't have any documentation on what the costs of the construction or widening of the road was, and for the first time actually today, from Mr. Middleton, I heard that there was the old township road was there beforehand too, so I didn't know that before today.
So what I'm looking at is Mr. Middleton says that he had a presumptive easement at one point, and that burned up in the town hall back in the day or something. And on the other side, we have somebody saying that they have $250,000 in a road improvement. Neither one can produce a record. So to me, those two pieces of information become pertinent in how we figure out. To me, I can't assume that there was that easement, and I can't assume that $250,000 is appropriate either.
I can't debate, I'm not trying to debate with you, Commissioner Barrows. I mean, all I have is the only possible response or additional information I can give you is if there was an easement deed and it was recorded, it would show up in the abstract or the Torrance title. At least that's what's supposed to happen. That's where we have abstracts and Torrance titles, and stuff's all recorded in the recorder's office. I also know historically the county courthouse burnt down, and we lost all kinds of information on county ditches, which we have spent decades trying to recreate 1 foot at a time, so to speak. So
Don, have you researched that as far as the?
county
the
ditches, no, not a lot of time on county ditches.
No, the easement, have we looked at that?
No.
So
I would assume
we're just
that
assuming
if-
there isn't then?
I would assume if the easement had been recorded, Mr. Middleton would have it. Yeah, I'm not saying it wasn't on his deed. I'm not saying he didn't think he had it. I'm just saying if there had been an easement deed recorded with the recorder's office, it should show up in his abstract. That's all I'm saying.
Seems.
Mr. Chair, just by way of background, there was, the FAD, to the best of our knowledge, has never been a township, and so the fire, I think, that he is referring to probably was at our shop.
Okay.
And we lost records. The first book of county board minutes is gone. And we lost it to a fire, did we not? It might have been the same fire, because the recorder's office was in the
What
same
year
building.
was that fire?
A
The
long
1800s.
time ago.
I'm assuming.
So
Might not even been this building.
that
It
would,
wasn't this building.
You
It
would
was
think-
up, it was up the street.
it seems like we've been having this argument since the 1800s, but the reality is, I don't believe that would have burnt up then, in our fire. That if it's indeed the case, why have we not researched that? Because it is a part of this equation. I'm not asking you, Teresa, I'm just.
So if I may, Mr. Chairman, to bring it back to center, it's not your job, nor my job, nor Land Services' job to do title searches for the parties involved in this business. Right now, to the best of your knowledge, you have a landlocked person who qualifies for a cartway. You, as the town board for unorganized territory, have an obligation to create the cartway where you believe is most appropriate. And once that's established, you need to award damages on a per ownership basis. That's what we have before us today. If there is title work that can clear up that the Middletons have an easement, that's currently Mr. Kruger's job. And then they can withdraw their petition because they won't need a cartway and they won't qualify because they have an easement to get to where they want to go. And I'm not trying to put the burden on Mr. Kruger. I'm just saying that's not your job.
Mr. Kruger,
Yes.
would you care to comment on Have we researched the issue of an easement, or?
That I don't know. I came in after Mr. Barnum, and Mr. Barnum handled those initial issues. I have to imagine that he did research it and was unable to substantiate it. However, I will double check with Mr. Middleton and the records that Mr. Barnum had in that regard.
Tim, did you want something, did you have something to say, or?
No, I was
Before I cut
answering
you
a
off?
question for Commissioner Brecken, that's all.
Oh, okay. Well,
So, Mr. Chair, what we're charged with is, at this point, we need to have a deposit of some sort to move forward, if I'm understanding correctly. Then we can legally move forward and we can determine which of the easements we're going to grant would be the cleanest process. Would that be correct?
Mostly, sorry. It is discretionary whether you require the upfront damage deposit. But once you've determined it, you can't proceed forward until you've collected it, is my understanding of the law. And I recommend that you set, and I already have recommended that you set some type of damage deposit to protect everyone involved. That's your decision to make, Mr. Chairman, or excuse me, Mr. Commissioner Barrows.
Didn't we set the 70,000? Do we have to redo that?
You do not, but you would have the discretion to reconsider it and modify it however you would see fit.
well, I'd heard a number of 15 to 20. How do I mean, I would be happy to make a motion. How does that work, Tim?
Mr. Chair,
Go ahead, Commissioner.
Mr. Chair, you could hand the gavel over to your
Vice Chair.
Vice Chair.
vice chair, and you can make the motion.
There's the gavel.
Okay, thank you.
So again, I think two things we need to accomplish are the damage amount and a firm date that this thing is going to finally be resolved. With that said, I would make a motion to reduce the damages to $20,000 until such time an actual route is selected,
Considering the motion. 15.
where then we can actually determine additional damages based on a factual route, so.
Would you also then like to set a date for? setting
Mr.
that
Chair,
up?
I think you gotta have a second first, so I would second that.
Okay.
Okay. We have a motion and a second to establish the damages at $20,000. Is there any further discussion?
Point of order, damage deposit.
Damage
not
deposit.
damages.
Correct, thank you, Don.
Any further discussion? Shall we take a roll call?
Commissioner Coring?
Aye.
Commissioner Brecken? Oh,
Aye. Oh,
well. Commissioner Barrows?
Aye.
Commissioner Franzine?
Aye.
Commissioner Hoag?
Aye.
okay. Motion passes.
Now, I think we need to set a new date for this to come back to the board to be resolved. I know, oh, go ahead, Commissioner.
Mr. Chair, just kind of a question for the parliamentarian. Would this be a separate meeting, being that we are acting as the town board? Would we doing this on a county board meeting day, or would we have this be, have to have it be a separate meeting?
Mr. Chair, Commissioner Coring, that does not need to be a separate meeting. You can act as the town board during a regular county board meeting.
Then couldn't we, Mr. Chair, so would the second Tuesday in May, would that be sufficient time? I guess I'm asking Don Ryan that. Would that be sufficient time to meet all the legal requirements that we have to abide by?
I believe that if we pick the May 10th date, Commissioner Corning, that we have sufficient time to be able to give the 10-day notice.
Can I just ask, so we're clear, who will be notifying the people?
I will personally coordinate with Therese and with Ryan Simonson from the Land Department. So you have 3 names, you can actually know one of us will get it done.
Okay.
You know I will. I just have,
So-
I thought I heard somebody say the second board date, which would be the 24th, and now somebody just said the 10th. So is it the
Let's do
second?
the 10th.
Yeah.
I'll make a
Okay.
motion for the 10th.
Okay. There's a
Didn't he already make a motion?
I don't believe so.
I did not make a motion. I
No,
was.
that was only discussion.
Wondering to make sure that we were having enough time to meet the legal requirements of notice. So, I believe now you've got a motion for the 10th. Would that be, that's our,
That's our
Correct.
first meeting. in
Correct.
May.
yeah.
Yep.
Yeah, I
Commissioner
would second that
Francine,
motion.
Commissioner Francine made a motion to set the date for setting the route on May 10th, our next board meeting. Would there be a second?
Paul.
I second that.
Okay. Commissioner Corning seconds that. Any further discussion?
One quick thing, that if that deposit is not made, that we will not be proceeding at that May meeting with this issue.
Correct.
Correct.
And I guess I will only add, because it's happened a number of times, that regardless of attorneys being able to make it or not, the meetings, this item will be on the agenda for resolution. So
As long as it passes.
I just say the end of kicking this thing down the road is done, so.
Okay.
Mr. Chair, do you wish to set the follow-on date of the 24th as well? The first date for determining the route, the second date for determining damages. I heard some conversation about that. You can do that at the same time if you wish. What are your wishes? I just want to be clear.
Would we need to amend the motion then to include that?
If that is your wishes, yes, that would be asking the mover and the seconder if that's a friendly amendment.
Is that what you'd like, Doug?
We have a motion on this, right, in a second?
Well, we could amend, we could amend the motions to include then setting the damages on the 24th of May, the second board meeting of May. Would you be open to that, Rosemary, of adjusting that, adding the
My
two?
only, I guess, is that we do have damages already predetermined depending on what route we select. Is it,
You do not, if I may, Mr. Commissioner Hoag, since you're currently not the chair, and Mr. Brecken is, you do not have damages previously determined. You have appraisals from one side with recommendations on what the damages would be on those 3 routes. You have nothing from the other side, and you have nothing from the affected landowners who are not here today. Just so everyone's clear, there's been no determination of damages, you just have information from one party in this proceeding.
okay.
Then let's set the date, and then we'll do the damages 2 weeks later, so they know what route, and then they can bring in
determine
actual.
Okay.
So the motion on the table then, as amended by Commissioner Francine, is that we'll be setting the date of May 10th to set the route, with a follow-up on May 24th to set the damages. You
Yes.
amend that? Is Commissioner Corning, are you were second to agree with that?
I do agree with that, Mr. Chairman.
Okay, any further discussion?
Mr. Chair, a point of clarification, do you want to set a time with that? If this is something that's going to consume your whole board agenda for a couple hours, we don't want to set it at 9 o'clock. We want to set it at a different time. I don't know what the agenda is going to be for the 10th yet, so sometimes it's half an hour, sometimes it's 4 hours, so.
We would suggest probably 10 o'clock.
10 o'clock?
It's a guess?
It can be later, but not earlier.
Yes, correct.
Okay.
So
we'll
10 o'clock
10
on the 10th.
We'll set that at 10 o'clock.
And
I'm okay with that, and then the lawyers don't have the meters running then, waiting for us to start the meeting, so we can try to save somebody some money, thank God.
Table the Is that a quick action or?
I doubt the 24th will be the quick action. In fact, I think the 24th will be the longer of the two, would be my guess. There's not a public hearing requirement here, but I think it's just when we're going to put it on the agenda so people know when to show up. I would suggest 10 o'clock for that item as well.
Okay.
And we could include both those dates, times, and places in the notice that we send.
Be in the same document.
Yep. And so we can put both dates in there so that everybody's got both dates. This is what's going to happen. This is when it's going to happen. This is where it's going to happen.
Okay.
Okay?
So we don't want this as a separate unorganized territory board meeting. It will just be part of the regular county board meeting acting as unorganized territory.
So technically, Teresa, how it will work is they will recess as county board. They will convene as the board for unorganized territory. When they're done, they will recess from that and reconvene as the county board without ever having to leave their chairs.
Thank you for the clarification.
Okay.
Defer to the parliamentarian to make sure I'm correct, but I think I am.
I think that's how we've done it before.
Any questions in regards to the motion and the second that we have standing? Okay, Teresa, if you want to take roll call?
Commissioner Barrows?
Aye.
Commissioner Franzine?
Aye.
Commissioner Hoag?
Aye.
Commissioner Coring?
Aye.
Commissioner Brecken?
Aye, and motion passes.
I have nothing more to bring before you on this morning, Mr. Chairman.
If I can, I'll turn the chair back over to
I think you're doing
Commissioner
fine. Well, that then concludes today's special meeting.
I'll make a motion
Thank
to
you.
adjourn.
Second.
Motion by Commissioner Barrows, second by Commissioner Franzine. Treese.
Commissioner Franzine?
Aye.
Commissioner Coring?
Aye.
Commissioner Brecken?
Aye.
Commissioner Barrows?
Aye.
Commissioner Hoag?
Aye.
Safe travels, Paul.
Thank you.
Thank you, board, staff.